across the world, including in Britain, from where we imported this law. Okay. This law has, sedition has been removed as a criminal offence. When Gandhi was arrested, he was asked, what do you have to say about these charges? And his essential defence was that it is my job to spread disaffection against the government. And I have done that, and I will continue to do it. Sedition is essentially used against people's movements, okay, against individuals who are protesting against the state, okay, against groups, organizations, whether it's the nuclear issue, whether it's individual cartoonists. Asim Trivedi matter went to the court, and the court asked them to, we were essentially saying that the section itself is invalid. But of course, the problem was in the High Court. We could not argue that for the simple reason that the Supreme Court has upheld the validity of that section. So we were essentially arguing that even if the section is valid, okay, it can be applied only in certain cases. The way it is being interpreted today is that as long as it leads to violence, it can be called a seditious statement. Okay? As long as the statement is against the state. What we are saying that yes, but this violence also should be against the state. It can't be that I make a statement, people come and beat me up, and you say it has led to violence, and therefore, because the whole idea of sedition, the purpose of law of sedition is to prevent a violent overthrow of the state. So when you are talking about whether it amounts to sedition or not, depending on whether it leads to violence or not, that violence has to be towards the state, it can't be towards an individual. Because if you are going to violently overthrow the state, if that is your fear, there are enough other provisions of law which can take care of it. You can charge a person for violence per se, you can charge a person for exhorting people, abetting people, conspiracy to commit violence. There are enough sections under the Indian Penal Code. When the punishment is life, see, it's a non-bailable offence. So bail can't be granted by the police, it has to be granted by the magistrate, okay? Or the sessions court, depending on what kind of matter it is. But I personally feel more than the bail, it's the chilling effect and the harassment which any litigation, any criminal litigation can cause, okay? Which is more important. Under the existing sedition law, as it is interpreted by the Supreme Court, okay, I am entitled to make legitimate criticism, even trenchant criticism of government or of its personnel. Okay, maybe the PM or maybe anybody else. Okay, I am entitled to make. That's not sedition. But this is not how it is implemented. See, law on paper and law in its implementation are two different things. Okay, so by the time I prove it is not sedition, I would be already in court for 10 years trying to fight out, already in jail for a couple of days. It targets even softened criticism of genuine criticism of the government. In 1950, during the Constituent Assembly debates, when there was a debate in the Constituent Assembly about what can be the reasonable restrictions to freedom of speech, which is a fundamental right under Article 19, that they said that we must have a clause concerning reasonable restrictions, where they said security of state, okay? They said defamation, they said contempt of court are reasonable restrictions which can be imposed through a law. The question, and one of the demands from some segments, some people from the Constituent Assembly was that you put sedition also as an exception. And Nehru personally opposed it, saying that no, it has to go because it has been used widely against people. Okay? Of course, they could have then amended the penal code and dropped the section, which they did not do. It was challenged in 4 high courts. All 4 high courts said that this section is contrary to freedom of speech and expression. And so all 4 high courts termed that particular sedition law as unconstitutional. Then it went to Supreme Court. Supreme Court said no, it's constitutional, but if it leads to violence. Over the years, if you see in 1947 and if you see today, the number of additional powers given, the number of additional things which have become crimes in the eyes of law. Okay, number of special laws which have been passed, whether it's POTA, TADA, UAPA, okay, or any of these kind of provisions, okay, has always increased. The number of offences for which death penalty is being imposed is more today than it was in 1947. Okay, so you have a whole over the years increase in the because the state, and especially more so in the last 20-25 years, when the state basically sees its role as enabling the corporate sector to flourish, and that is basically two things. One is of course allowing all kinds of land acquisition, etc., and displacement, and two, controlling people's protests through police power, more and more police power. So the police power laws have increased over the, especially the last 20-25 years.